If you're a taxpayer who's been receiving advice that it's good enough for you to cease residency simply because you've been out of the country, say, for 330 days, I would not view that as absolute peace of mind until SARS has documented that on a formal letter indicating the basis of the days or the time rule for that matter.
A very big welcome to everyone who does click on this and watches. I know we've got a lot of faithful and loyal listeners and a big audience, and really appreciate that firstly. Today, incredibly excited, I must say, even myself being a specialist in tax residency, to be joined with Delana Abdul, the legal manager of cross-border tax at Tax Consulting South Africa, in terms of which we're going to be talking about obviously ceasing tax residency, but more so from the sense of what options do you have, and just dealing with, if I may say, a big misconception when it comes to specifically one in particular. Delana, a pleasure to be here with you.
Thank you, John Paul. I think if I can jump straight into it, there's a lot of day-to-day taxpayers that approach us, and it's not always clear if they've received the correct advice. And the advice that we're referring to here is ceasing tax residency from a SARS perspective. A starting point on that is one can only cease their tax residency status with SARS through a formal application. In other words, one needs to make a request in order to have their status updated from that of a normal resident taxpayer to a non-resident taxpayer. Circumstances, however, will dictate on what qualifying bases a taxpayer can make that request. And if one looks at SARS's website on this topic, there are three qualifying bases. The first one is ceasing your tax residency status in South Africa under the ordinarily resident test. The second would be due to the application of a double taxation agreement. And the third one often has a variety of misconceptions, but it certainly is a qualifying basis, and that's under the physical presence test. By virtue of leaving South Africa for a certain number of days, but importantly, taxpayers must ensure that their advisors can evidence to them that SARS has got that status of non-residency on record per a non-res letter.
And I think, if I may jump in here, very well said. But in terms of physical presence, I think very important to emphasize that as well. So just in terms of your insight or the importance of having that for specifically this basis, what are your thoughts in that regard?
One thing I can say is, irrespective of one's view and interpretation of residency laws in South Africa, there is only one body that can verify and confirm that status as a non-resident, and that is SARS. SARS, if they agree with your interpretation of the law, will issue you with a notice of non-resident tax status confirmation letter. With physical presence, it's often a very loose discussion with taxpayers and advisors. And what's important for our viewers to understand is that if they are receiving the advice that they can break residency in South Africa by way of this physical presence test, also referred to as the days test or the time rule, they should be able to evidence to you that SARS has issued a non-res letter where the qualifying basis specifically indicates the physical presence test.
And in terms of those who may not have that, which is very common that I come across all the time, what advice would you give in terms of not being able to evidence that you are a non-resident by way of the physical presence test?
I don't think taxpayers ought to take a view that tax residency is a once-off assessment. In many instances, it's a yearly assessment. The same applies, for instance, to breaking residency in South Africa by way of a double taxation agreement. SARS holds the view that this is an assessment which ought to be done on a yearly basis. And if you break your residency by way of a double tax agreement, you must appreciate that one tax residency certificate from a host country does not in and of itself mean that you are a non-resident in perpetuity. So the yearly assessment is very true to how you break residency under a double tax agreement. Why I use that reference is because the physical presence test is also an annual assessment. And if one triggers residency in South Africa by way of the physical presence test, you must keep in mind that leaving the country in and of itself will not mean that you automatically become a non-resident. SARS must verify and confirm the position. And in doing that, they ought to issue you with a non-res letter, again, with the qualifying basis being clearly indicated. If you're a taxpayer who's been receiving advice that it's good enough for you to cease residency simply because you've been out of the country, say, for 330 days, I would not view that as absolute peace of mind until SARS has documented that on a formal letter indicating the basis of the days or the time rule for that matter.
I do think, again, to come back to the point of, and very well said by yourself, is until you have that non-resident letter confirmation by SARS, you will be deemed a tax resident in South Africa, irrespective of whether it's physical presence or not. And I don't know if you have any final thoughts or final comments, or maybe just some words for the audience that maybe are unsure in terms of this, whether they have it or not.
I think my closing comments would be that a taxpayer, whether you are a foreign national or a South African national, should not resort to a self-assessment of their tax affairs, more specifically their tax residency status. They must give SARS an opportunity to verify and confirm that position. And doing the assessment with someone who is an expert is critical, because not only will the Revenue Authority confirm your non-residency, but they will confirm the non-residency under a particular basis. That basis has an impact on how you will file your tax return, what you will disclose in your tax return, as well as what will your obligations be as a taxpayer in order to discharge the burden of proof. We know that the Anglo-Platinum case, where the Supreme Court of Appeal, for instance, mentioned to us that you need to look at objective factors, and in particular, objective documentary evidence. Oral evidence can be submitted, but it is documentary evidence which will confirm your tax position, even in the context of residency.
Thanks, Delano, again. Prudent and very wise words. And I do want to encourage the audience that if you are unsure, uncertainty is definitely not a game to play with SARS. So if you are concerned or unsure about this, please do reach out to individuals such as Delano, who can perform a tax diagnostic, for example, to confirm whether your status has been correctly updated or not, and whether you've received that notice or not. And if not, he's also the perfect man to make sure that you do get it. So Delano, again, always a pleasure. Thank you very much for your time, and hopefully see you again soon.
Thank you.
Thanks to our listeners as well. And please, by all means, click on the link below if you are looking for a consult. We are always happy to help. And thank you for watching.